They are convicted of a crime.
Wow, you all are very obedient. I didn't even ask you to be quiet. It is time for our presentation today, which will be by Professor Sean O'Brien. He's in the School of Law. He's Board of Directors for the Innocence Project, and he's going to talk to us about that project and some of the work he's done with it, which is really exciting stuff. I know I've seen him talk about it on 60 Minutes. You're famous. His resume goes on forever, so I'm not going to go through all of that, but we're really pleased to have him here today. I'll let you take it away, Sean.
All right, thank you. Well, good afternoon. It's an honor to be here. Thank you so much. I was surprised to learn that everybody here is retired because you all look too young. But I'm going to join you at the end of August. And so I know I look too young too. So, well, thank you. I wasn't sure, what to put together to present to you, so I thought I'd just tell you some stories of the clinical work that I've done over the years. And explain a little bit about how my education at UMKC and even my undergraduate degree in English has been a tremendous assistance in doing this work. I started my career, believe it or not, as a tax lawyer. People are surprised to learn that, but I started out doing tax work and I didn't like the clients so much. They're all trying to hide their money from the government, and at the end of the day when I helped them do that, I didn't have that, a soul fulfilling experience. And so I got a court appointed case, and I loved it. It was great. And so I moved over to the public defender's office in 1981, became the chief public defender in 1983. After that, I left in 1990 to start the Missouri Capital Punishment Resource Center. And I had thought at that point that I had gotten to be a pretty good lawyer. But I realized that when you're representing a client whose life is on the line, that it calls for an even higher level of advocacy than you can imagine. And so I have some, I'm going to show you some pictures of some clients and kind of take you through the big picture and the small picture of the criminal justice system. I'm known today as an innocence lawyer because I founded the Midwest Innocence Project, and I do a lot of work with the National Innocence Project. When Barry Scheck has an innocence case in Missouri, I'm his local counsel typically. And so I want to tell you just some stories about some of my clients. Top center is Faye Copeland. And some of you may remember the Copeland case. Ray Copeland was convicted of killing 5 ranch hands. And he had a cattle fraud scheme where he would hire people from homeless shelters and then explain to them that everybody knows me, so when I go to an auction, they bid against me just to drive up the price. So I need a straw man for the sale. So he would open a bank account, and then he would send the homeless person in and tell the homeless person what to bid on. The homeless person would buy the cattle, write a check, then Ray would beat the check to the bank, clear the money out, and then murder the homeless man and bury him in the barn. All the while, he was married to Faye. And she went to trial first and was found guilty because she was represented by a lawyer who was an alcoholic, who didn't really do anything, relied on a battered woman defense without finding a single witness who could say that she was a battered woman. Unless you have firsthand evidence, you can't do that. And so one of the first things that we do is write a biopsychosocial history. So we turn to students in the School of Social Work. We look to psychologists. We learn what are the standards of that profession. Because the most important thing in a mental health evaluation, we learned, is the client life history. And so I had a young, also English major from Harvard Law School working for me one summer. And he and I were working on Faye Copeland's case back in 2001. And he was a gifted writer, Chris Bauman. He's now a managing partner at Reisman and Barget in St. Louis. But the first line of Faye Copeland's biopsychosocial history was written by him. And it's such a beautiful sentence. It says everything about Faye that I remember it today. It was, Faye Copeland gave birth to her first son in a dirt-floored cabin illuminated by the lights of a Depression-era car. So what do you know about Faye Copeland from just that one sentence? The second sentence was her father was a Baptist preacher. And rather than bear the shame of an illegitimate grandson, he forced her to marry her rapist. That's Faye Copeland. And that brings you into that story. And so we're learning about, we teach law students how to unlearn what they learned in legal writing and learn how to write a good story that leads the listener, the reader, to the conclusion you want them to reach without beating them over the head with it. Those are the best conclusions if you reach and you own them. So Faye actually died a free woman. We managed to get her off of death row, and then we convinced Mel Carnahan to give her a special commutation. It was like a parole. Yes?
Which one of those guys is Ray?
Oh, Ray is not on here. I didn't represent Ray. Okay. Yeah. This fellow is Ramon Martinez Villarreal. He was sentenced to death in Arizona. And we did the same thing with Ramon, and digging into his background. He grew up in an ejido in Guanachivi, Mexico, which is a 6-hour Jeep ride from Chihuahua City. Very impoverished town. This picture doesn't really show it. I need to have somebody standing next to him. He's only about this tall. He's 4 feet 8 inches high, and was convicted of a double homicide. And the opinion affirming his appeal talked about what a cold-blooded killer he appeared to be. Because as he's sitting at the trial, he's turning around and grinning at everybody in the courtroom. And the victim's family is in the front row, and he smiles. And he waves at the victim's family as if he's taunting them. When he was arrested, he was wearing a pair of boots. When the judge grants allocution, where the judge looks at the prisoner after conviction and says, "Do you have anything to say for yourself before I pronounce sentence?" Ramon replies, "When do I get my boots back?" Those were reported as evidence of his bravado, his cold-blooded, callous attitude toward the lives he was taking. And that is where the case stood until we got involved in it after he had been on death row for almost 1983 to 1997. What's that, 14 years? And of course, talking to him through an interpreter, we had a very good interpreter. And that's where, one of the things I want to impress upon you is the importance of doing this kind of work in an interdisciplinary manner. We need nurses, we need social workers, we need people from various professions who can help us. We had an interpreter who was the most amazing interpreter I'd ever heard. So nobody knew that Ramon stuttered in Spanish until we got a really good interpreter. And that he spoke a dialect of Spanish that is in this really isolated, you want to talk about an undocumented person. He didn't have a birth certificate. He had never been to school. And so it presented challenges with how do we do a biopsychosocial history for someone who did not generate a single piece of paper through the course of his life. And so we ended up hiring an anthropologist who had worked with UNICEF in delivering UNICEF services to the village where Ramon grew up. And one of the things we have to prove in order to establish, a good mental health evaluation, especially, when we find out that Ramon's IQ was 59, some of you know what that means. How do you prove that his intellectual deficit pre-existed age 18? And so we needed an anthropologist to help us properly interpret Ramon's culture. So we were misinterpreting some things. Ramon did not know his birthday, didn't know what day, didn't know how old he was. And we found out that in his culture, they don't mark birthdays. Nobody knows what their birthday is. So if we thought that was evidence of his, intellectual deficit, we were wrong. But the things that became important were that in his culture, he should know how to harness a mule by age 10. He never did learn how to harness a mule or operate a hoe or basic, subsistence level agricultural work. And so we were able to establish his case. I have a funny story about his case. The trial judge, the issue in his case when I got into it was whether he was mentally fit for execution. Every other issue in the case had been disposed of before I got there. And so I stepped in to litigate just that issue. Is he mentally fit for execution? To be fit for execution, you have to, number one, know that you are under sentence of death. And number two, that sentence of death is because you are convicted of murder. And you have to be able to causally relate those two things. And that was the only issue. As we started digging into Ramon's background, we found he was too impaired to meet even that basic standard. So I quote to the trial judge we're in front of, his name's Boyd Johnston. And if you can imagine Wilford Brimley as a judge, big walrus mustache, wore a cowboy hat to court. And I quote Ford versus Wainwright, which is the controlling Supreme Court decision. So I quote that to him, and he looks at me and he says, "Son, I've been on this bench for 20 years. And if I'm on this bench for 20 more years, maybe the Supreme Court will look at one of my cases. And maybe they'll tell me I'm wrong. But I reverse 2 or 3 of theirs every day." So he wanted me to quote him some Arizona law. Lo and behold, we did get all the way to the US Supreme Court. And we won. And they sent it back to us. I said, "Hi, Judge Johnston, remember me?" And he recused himself from the case. And that took just long enough for the US Supreme Court to decide a case called Atkins versus Virginia, which ruled that the 8th Amendment prohibition of cruel and unusual punishment prohibits the execution of intellectually disabled people. And so there was one more mental evaluation after we came back. Opposing counsel in the case hired her own expert. The opposing counsel was the Attorney General of Arizona. You may recognize her name. She was Janet Napolitano. And then they got the evaluation back, and the doctor said, "I can't help you. This guy is clearly intellectually disabled." And so she agreed that if the Atkins v. Virginia decision breaks our way, she would stipulate to a new sentencing hearing. It went our way, and she stipulated to a new sentencing hearing. And then we didn't go to the sentencing hearing. We argued that Ramon was too mentally unfit to be competent to proceed to a criminal sentencing. And the trial court agreed with us. It wasn't Judge Johnston anymore. Committed him to the probate court. This picture, this is Ramon in the sheltered workshop in the Arizona State Hospital, which is where he belongs. He's happy as a clam. After 20 years of litigation, we got him there in 2017 from 1997. And with clinical students working all the way. Some of my favorite clinical students have been people working on their JD after having earned a Master of Social Work degree. And so, you know, Ramon I still talk to him periodically. I need an interpreter on the phone, but now I'm close to retirement, I'm doing Duolingo, so maybe I can talk to Ramon. Bottom center is Heath Wilkins, who was one of the youngest people sentenced to death in America. Heath is free today, not because he's innocent, but because we got him a new trial and a parolable life sentence. And then on the right is Steve Parkas, who was the first prisoner in Missouri to be removed from death row because of the Atkins v. Virginia decision. And these are just some of the faces of people I've represented. So I like for people to understand that I did not start out as a criminal lawyer. I did not start out as an innocence lawyer. I started out focusing entirely on excessive sentences. But I ran into a guy named Lloyd Schloop on death row who told me about the prison guards and how they had literally framed him for murder. And he gave me this really elaborate story about who was connected to whom, and and how he got framed for a murder that was actually committed by a fellow by the name of Rocky Jordan. It was such an elaborate, far-fetched story that I actually considered and did hire a psychiatrist to evaluate Lloyd because it seemed disconnected from reality. And then I started investigating the case, and after we came so close to execution on Lloyd's case several times. In March of 1992, I don't know how to measure the time because death warrants are carried out a minute after midnight. We had a stay of execution going right up to that minute after midnight, but it was being challenged in the US Supreme Court. So it was like 5 o'clock the next day with the gurney parked right outside the door. And if that stay of execution had been lifted, he would have been executed in March of 1992. There's an interesting footnote to this case. I was working with another lawyer in Georgia named Mark Olive, who had a client in Texas by the name of Leo Herrera, who was scheduled to be executed on the same night. And we both asked the Supreme Court for a stay of execution. And we collaborated on the certiorari question, same question in both cases. It was, does it violate the 8th Amendment to execute an innocent person? Well, that's a good question. Because it would be hard for them to say no, right? And in Lloyd's case, our investigation showed from the prison surveillance camera that Lloyd was in the dining room a quarter mile away from the scene of the crime when the murder happened. In Leo Herrera's case, he had a hearsay statement about a dying declaration of Herrera's brother saying, "I did it, Leo's innocent," which is barely even, it's not even admissible in court. So with that same issue in two cases, they rejected certiorari in our case and granted certiorari in Leo Herrera's case, and then ruled, well, we don't have to answer this question because you're not innocent. Yes?
Certiorari, what is that term?
Certiorari is the process by which the US Supreme Court can review the decision from a state court or a circuit court of appeals that raises a constitutional issue. Very few cases get directly appealed to the US Supreme Court. Generally, they have the discretion to hear or not hear almost anything. And so you have to file a petition for writ of certiorari. And if 4 justices want to hear it, then the full court will hear it. But to get stay of execution, you need 5 justices to grant the stay of execution. So we didn't get our stay of execution from the Supreme Court. We got it from a lower court judge, which gave us more time to investigate. And as we were investigating, I went to visit the mother of the homicide victim in our case. Nobody had ever talked to her before. She's an African-American woman. She was a sharecropper on a cotton farm in Pine Bluff, Arkansas. And we brought the file down. She wanted to see it. We showed her the affidavits of eyewitnesses. Lloyd was a white prisoner, you can see. A lot of our witnesses who were saying Lloyd was innocent were black prisoners. And she knew a lot of them because she would go on food visits and take buckets of fried chicken into the prison, so she knew them. And in November 1993, we lost our petition in the lower courts. Lloyd was scheduled to be executed on November the 19th. The Attorney General was putting out all kinds of publicity about the case to try to get Lloyd executed. At 10 a.m. on the 18th, the governor's legal counsel called me and said, "We're not going to stop this execution. The governor doesn't think you have enough." And so I hop a plane, fly to St. Louis, and drive down to Potosi. I get there after dark, and sitting in the death watch cell with Lloyd. And it was a horrifying experience. If you could imagine a room, well, it's basically 12 by 12, so just this little corner of the room. One end of it is blocked off by a mesh screen where the mesh is so fine you could barely see through it. You can tell there's a human on the other side, but you couldn't make out facial features. But I knew, of course, that Lloyd was back there. He was, there was a chair next to the screen, and I was sitting on a stool next to the screen. And I remember, he was trying to touch me through the screen, and so I tried to touch him through the screen, pushing so hard that our fingers bled. And then it was at that point that we got a phone call from the governor's legal counsel, stopping the execution. And total shock. It was about 9 p.m. So we had 3 hours to go. The gurney was parked right outside the door. This ran in a publication called The Lawyer's Media, or American Lawyer, rather. They're the overall group is Lawyer's Media. They do court TV, but this is a magazine that goes right to the chambers of the Supreme Court. And this journalist, Stuart Taylor, looked at our case, did some independent investigation, and there's the headline. He didn't do it. So because Governor Carnahan stayed the execution, we had a full 90 days to petition for certiorari to the US Supreme Court. They granted the petition for writ of certiorari. And I found out the next day after Governor Carnahan granted the stay that Mrs. Dade, the victim's mother, had called the governor and said, "I know these boys who are saying that Mr. Sloop is innocent. If he was guilty, they would not be standing up for him because they were my son's friends. Don't kill that boy. He didn't do it." So he decided to stay the execution. You probably heard the term actual innocence. Barry Scheck published a book a few years after this case called Actual Innocence. Actual innocence comes from the US Supreme Court decision in Lloyd Sloop's case that says if a prisoner can make a colorable showing of actual innocence, he's entitled to have his habeas corpus petition heard on the merits it doesn't mean he gets off of death row, but it means he gets to litigate the constitutionality of his sentence. That standard is called the actual innocence standard. And this is the case that makes me known as an innocence lawyer. In fact, last week I was in New York City. The National Innocence Project gave me the Freedom and Justice Award for this decision and many others that followed it. And so it sets the standard for actual innocence in American habeas corpus cases. So I got to then get involved in innocence cases And so for me, in order to take an innocence case, I'm not like the Innocence Project, where I dig into the case and I have to be convinced that you're innocent, absolutely. For me, I just look to see if you got a fair trial, right? Because you'd be surprised how many times, if you don't get a fair trial, you get convicted when you're innocent, right? And so that's my criteria. But I have been involved since then in dozens of cases, working with clinical students on innocence, and I still continue to do death penalty cases as well. Although I finished my last death penalty case in 2022. I'm getting too old for that. I'm not going to do another one. And so I want to share with you some of the big lessons and the small lessons of innocence in our criminal justice system. So this is a graph that shows the number of prisoners in America, 2.3 million, and 375 DNA exonerations. I should update that slide. It's more like 450 now. But even with 450, it doesn't show up. It's invisible given the small percentage. The estimates are that between 5 and 12% of people in prison are innocent of the crimes they're convicted of. And what they're doing is taking other data and projecting it across all the cases. I'm happy to take questions anytime if anybody has questions. I'm just kind of sharing some thoughts about it. But when you get to the death penalty, those numbers change. It's a smaller pool of cases to begin with, but the numbers show up. Of the 400, there have been 450 DNA exonerations. There have been 202 death row exonerations. Now the DNA exonerations cover all kinds of crimes, capital and non-capital. They're mostly non-capital. The 202 exonerations are all death row exonerations. But here's where they overlap. Only 20 of the death row exonerations were accomplished by DNA. There's a reason for that. The reason is that for DNA to be probative, the perpetrator has to leave genetic material behind in a way that is unambiguously the perpetrator's. Those are usually sex cases. And so in homicide cases, unless that homicide is accompanied by a sexual assault, you typically don't see that. So here's how it compares to the death row population as a whole. There are 2,213 people on death row, 202 exonerations. I don't know that we can say from that almost 10% of the people on death row are innocent, but at the end of a case, one of two things is going to happen. You're going to get off of death row or you're going to be executed, right? And so it is a warning that there is a problem here. And I guarantee you that if you owned a parachute factory and had these numbers, they would shut you down, right? This is our criminal justice system. When we look at exonerations versus executions, it gets even higher, right? So if we're only looking at executions from death row, it's over 10%, right? These are kind of scary numbers, frankly. And so we have learned to look at wrongful convictions cases and reverse engineer the conviction to figure out what kind of evidence caused the convictions. This kind of generates red flags for us so that we know what to look for in a case that we're reviewing for potential innocence. So based on the first 210 DNA exonerations, government misconduct was responsible for about a quarter of them. False confessions were responsible for, quite a few, more than 10% certainly. I used to think if you heard somebody confessed, you'd think they were guilty, right? I'll talk a little more about false confessions in a little bit because our last exoneration was a false confession case. Snitches, Barry Scheck gets that after me when I say snitches. It's a slang term among criminal defense lawyers. He prefers that I use the term incentivized witnesses. That doesn't fit as well on a PowerPoint slide. So apologies to Barry, snitches. And those are, cellmates or people. Some people are very skilled at being government informants. They'll listen, they'll study a little bit about the case, and then they'll send a kite to the guard saying, hey, I heard this guy say, X, Y, and Z. There was one guy in Los Angeles who was really good at it. There was an exoneration before the DNA era back in 1984, 85. Bernard Chance and Benny Powell were convicted based on an informant's testimony, and the informant had his girlfriend call a little factoid into the TIPS hotline. And then he put that factoid into a note that he sent to the guard saying, hey, I just heard Benny Powell say that he did this. And he said blah, blah, blah. He put that little factoid in. And the detective gets that note and says, how could he know that? Well, he planted it in the investigation. These people can be really, really clever and determined. And so we watch out for that. The other thing that's happening, and this is where, the practice of law, it gets, works in a multidisciplinary team. One of the things we always thought was junk science was microscopic hair comparison, where you take a hair from the crime scene. Has anybody read the book The Innocent Man by John Grisham?
Yep.
All right, that is the quintessential case, right? In fact, Dennis Fritz, who was Ron Williamson's co-defendant, the other innocent man, was on the board of directors of the Midwest Innocence Project here until he passed away a couple years ago. But I got to be good friends with both Dennis and Ron. So the victim in their case had hairs clutched in the palm of her hand that a crime lab, a crime technician, her name was Joyce Gilchrist, said belonged to Dennis Fritz, and other hairs belonged to Ron Williamson. And that was used to convict, along with, guess what, a jailhouse informant. Sometimes these things act together, so you have the jailhouse informant corroborating the hair and vice versa. And the original study was that validated microscopic hair comparison is based on probabilities. They looked at 32 people and they examined their hairs under a microscope and sorted them out based on characteristics. So if you pull out one of my hairs, if you find one, it says, they'll look at it, they'll look at for color. They'll look at it for thickness. They'll look at it for texture. They'll look at it for whether it's straight or curly. And so if, based on this study of 32 people, and the scientists in the room know that's not a valid sample, right, statistically. If 1 in 10 people have red hair, 1 in 10 people have coarse hair, 1 in 10 people have fine hair, and 1 in 10 people have curly hair. If you find a red, coarse, fine, curly hair, it's 1 times 10 times 10 times 10, so, yeah. Oh gosh, 1 in 1,000, 1 in 10,000. And then they would say there's a 1 in 10,000 chance, or even worse, they would come in and say the defendant's hair matched the hair that was found in the victim's palm. They were convicted on that evidence. Now here's the entry, and here's why I don't screen cases strictly for innocence. I screen them for a fair trial. Ron Williamson got a new trial from the 10th Circuit Court of Appeals because he was a very mentally ill man. Made the perfect patsy for a murder case because everybody says, oh yeah, that guy's really strange, right? And in the middle of his trial, he had a psychotic episode. he acted out. He started swearing at the jury. He's swearing at the judge. He's swearing at his lawyer. He doesn't abide by any of the court's instructions. And the trial lawyer does nothing. And the 10th Circuit Court of Appeals found that the trial lawyer should have asked for a psychiatric evaluation of his fitness to proceed. And had he done so, they would have found that Ron suffers from bipolar disorder with psychosis, and that was going on. So he got a new trial because of that. And while his new trial was pending, his case caught the attention of Barry Scheck, who saw that there was hair evidence, and lo and behold, they did DNA testing. And here's the new technology that came along. Mitochondrial DNA can be extracted from the shaft of a hair. So they were able to determine that none of the hairs in the victim's hand belonged to either Ron Williamson or Dennis Fritz. But here's the other thing. The jailhouse snitch, who initially made up a confession by Ron Williamson, was named Glenn Gore, and he gave details of the crime that only the killer had known, and that's how they convinced the jury he was telling the truth. All of the hairs belonged to Glenn Gore. He was the killer, right? And so microscopic hair evidence, and the expert had come to court and said, these hairs belong to Dennis, these hairs belong to Ron. I compared all of them with Glenn Gore, not his hair. Everything he said, or she said rather, was wrong, right? So microscopic hair comparison is just one manifestation of junk science. There are lots of others. Forensic odontology, you could maybe use it to make an identification of a deceased person, but bite mark comparison, absolutely not. It's junk science. It's not empirically informed. And then mistaken identification, the leading cause. So if you have an identification case, you really need to look deeply into that, because that is that's sort of the biggest red flag that we have, right? And so in death penalty cases, when we look at the 200 exonerations, government misconduct goes way up. You would think that it would make the seriousness of the death penalty would make everybody behave better, right? Has the opposite effect on police and prosecutors. I think it's because they always involve terrible crimes, and the pressure to solve those crimes is great. And they take shortcuts in using junk science and informants. And informants know that if they're in jail facing a serious charge, you just need to find a bigger fish on the docket, make up a story, and you can get out of prison, right? And so all of these things go up. False confessions, perjured testimony, discredited science. See, that's a compromise with Barry. That's okay, we'll call it, he has the same thing about junk science. Okay, I'll call it discredited science. And because there are fewer eyewitnesses to homicides, mistaken identification represents a lower percentage of the cause factor. But this is kind of what we're screening these cases for. And every one involves a combination. It's never just one thing. And the other thing that is common to many is defense lawyer incompetence. It's one of the reasons I decided to teach in a law school, frankly, because when defense lawyers get lazy, or when defense lawyers decide on their own, I'm going to give this client my A game, but this guy seems guilty to me, he gets my B game, that's short-circuiting the jury system. And so lots of times when police commit misconduct, when prosecutors commit misconduct, good defense lawyers, Johnny on the spot, we call them on it, and we assert appropriate remedies. But if your defense lawyer is a slouch, or overworked, or undertrained, then that protection isn't there in these cases. So looking at Missouri prisoners, this is kind of how it shakes out. There have been 55 exonerations in Missouri since I've been practicing law. I use 1980 as my cutoff point. Of those 55, only 10 were able to prove their innocence with DNA. 45 had no DNA evidence. So we have to do it the old-fashioned way. I teach a class in investigation, principles of investigation, how to interview witnesses, how to obtain documents, how to ferret out physical evidence, and how to dig through. And so in all of these cases, you can imagine a team of law students digging through files and reading. You know, Benjamin Disraeli said, "Before I was a genius, I was a drudge." We have to teach the drudgery of it in order to succeed in these cases. And so this gives you just another snapshot of prisoners freed in Missouri.
Question?
Yes?
So when you're talking about DNA evidence, I'm just curious. I mean, DNA fingerprinting was developed in the mid-'80s.
Yes.
And there's been a lot of things that have happened since the mid-'80s.
Yes.
When you look at DNA evidence, is there a cluster in terms of years of when the DNA was helping to exonerate people?
You know, you would think that it would dry up after a while, right? But that's not been the case for a couple of reasons. One is that DNA technology has advanced. And so in the 1980s, we had the what's called the RFLP type of DNA that was not as accurate. In fact, of the exonerations in America, there were 3 people convicted on incorrect DNA inclusions, right? So when STR and PCR DNA came along, that more detailed picture of the DNA molecule showed differences. We thought it was their DNA, but no, it's not their DNA. And so they were exonerated. But the advent of mitochondrial DNA in about 2001 and 2002 spun a lot of exonerations from that, because people who were convicted on hair comparison now could get DNA from the shaft of a hair. And we could get DNA, it used to be in the 1980s, late 80s, you needed a drop of blood or human tissue about the size of a $50 in order to reliably test it. And the other problem was lab standards, right? So contamination is another thing that can result in wrongful inclusions. But as we go further, we can get smaller and smaller amounts. We can now get DNA profiles from microscopic traces of DNA. What is now called touch DNA is, less than 15 years old. And so I had a client charged with a homicide, and while the charges were pending, they got touch DNA of the real killer from the surface of the rock that was used to bludgeon the victim to death. And so it's amazing. But here's why we do it. My favorite thing is the family reunions, right? This is Dale Helmig and his brother Rich. Ellen Reason over on the top left, Joe Amrine on the top right, or next on the right, and then Rodney Lincoln on the upper right, and Ted White on the lower right. There's nothing like being present for this first hug from family when they get out of prison. That's all, you know, everything I do is pro bono. So this is my payment. What you're seeing is my fee over all this time. Ellen Reasonover was convicted solely on the testimony of a jailhouse snitch. The detective who worked the case they actually sent a career forger into her cell to try to get Ellen to confess to the crime. They wired her for sound. They recorded the conversation. This career forger, a woman named Rose Jolliffe, came out of the cell and said, "Ellen confessed to me." They used her testimony to convict Ellen. They did not disclose the tape recording they had of the conversation that was completely innocent. Completely innocent. She was expressing sympathy for the victim. She got called in as a suspect because she's the mother of a 2-year-old. So she does her laundry in the middle of the night. Baby's asleep, she'll run up the block, she could do 5 loads at once, get it done quickly. She went to the gas station where the murder happened to try to get change. Nobody came to the window. She kept tapping on the window. Somebody poked his head out from the back room and then pulled back in. And she tapped again. Nobody came out. And the next morning, her mother called her and said, there was a murder at that gas station last night. And Ellen realizes, oh my gosh, I may have seen the killer. So she goes down and they show her mugshot after mugshot after mugshot. And then they get suspicious of her because she's not coming up with anybody, right? They're pulling every trick in the book to try to get her to identify somebody, and she doesn't. She doesn't see the perpetrator. So they suspect her, and they arrest her, they put her in the cell, they send Rose Jolliffe in, and that's how they got her convicted. This is her hugging her daughter, who was 2 when she went to prison, 18 years old when Ellen got out. She missed her high school graduation by 3 weeks. Joe Amrine was convicted and sentenced to death in the same prison. Lloyd Schlup was convicted of a prison homicide. I think you may have picked up on that. Joe Amrine was also convicted of a prison homicide in the same housing unit, put together by the same investigator. And they brought in jailhouse informants, 0 physical evidence. And so those 2 cases, we kind of worked them up together. Joe came very close to execution because his court-appointed lawyer missed the deadline for his notice of appeal. His family reached out to me. I stepped in. I got the appeal reinstated. I knew nothing about his case other than that. Got the appeal reinstated, and then as we're going up the ladder, we actually lost in the US Supreme Court. Joe lost his stay of execution, and there were 10 other prisoners who lost their stay of execution at the same time. And we're petitioning the governor. We petitioned the Missouri Supreme Court for state habeas corpus relief under the state constitution. Nobody had won one of those before, and so it was a long shot. It was a Hail Mary, literally. So the Missouri Supreme Court at that time was executing 1 prisoner a month. We had no idea who it would be. I think they were drawing straws or lottery number, but what they would do is execute somebody a minute after midnight, and then at 9 a.m. the next day, they would issue an execution warrant for the first Tuesday of the following month, a minute after midnight. And so Joe was in that pool every time. And the guards, when they came into the unit, is a big room, maybe about this size, but it has an upper tier and a lower tier. They call it a pod. The guards would come in the pod with the execution warrant, and they would look at the warrant, and they'd look up at the cell, and then they'd settle on a cell, and they'd walk toward it. Everybody knows that's the warrant. And then they'd stop and they'd go over here to this other prisoner. And then they'd pull them out of the cell and they'd read the warrant at the top of their voice. On the 3rd day of October 2002, the warden is directed to execute Michael Owsley by lethal injection. Off you go. So Joe saw that happen. And he saw it happen with, I mentioned Michael Owsley. Joe and Michael went to junior high school together here in Kansas City. They were friends. And after Michael's execution, Joe called me. There'd already been 6 executions before Michael. Joe called me and he said, can you arrange for me to go next? I cannot do this one more time. All 10 of the other prisoners had their executions dates come and go. And on that first Tuesday, we got, and this was the first Tuesday in November of 2002, we got a briefing schedule from the Missouri Supreme Court on our habeas corpus petition. They had never done that before. But We did it. I made the argument. It was February 4th, 2003, where I argued that it didn't matter what previous courts had decided in Joe's case. You know, there had been a bunch of courts that decided that Joe Amrine had a fair trial. But the evidence of his innocence by that point was overwhelming. And the Attorney General actually argued to the court that that didn't matter. Judge Laura Denver Stith published a law review article where she quoted from the transcript of the closing argument, where she asks the Attorney General, a young lawyer named Frank Young, I want to make sure I understand what you're arguing. Let's say that Joe Amrine had DNA evidence. Let's say that he could prove beyond a shadow of a doubt that he did not do the murder. Are you saying we should still execute him? And he said, that's correct, Your Honor. Wow. Yeah, I mean, that was the reaction of the court too. And so 2 or 3 other judges asked the same question. Even Rush Limbaugh's cousin, who was on the Supreme Court at the time, said, repeated that question. He gave the same answer every time. And so April 18th, the Missouri Supreme Court granted a new trial. Now, we had been asking for evidence of a little drop of blood that was on Joe's shirt. So we could test it for DNA, because by 2003, we could do that STR procedure. Don't ask me what any of that stands for. But we could do that, really specific DNA testing. And so we were asking for it as early as 1997, 1998, all the way through. They produced affidavits from the Highway Patrol Crime Lab saying all of the evidence was consumed in the original testing. There is no evidence to be had. So in April of 2003, when the Missouri Supreme Court said, you have to release Joe Amrine or retry him in 90 days, 2 days later they filed a motion for additional time because they found the DNA that they claimed didn't exist. So we had to wait for that DNA. It came back, negative. And so July 28th of 2003, Joe walked out of prison. So here's the other interesting thing about, you might guess that there's some corruption involved in these cases, and you might be right. I took my file in Joe Amrine's case and Lloyd Schloop's case, and I went to see a friend of mine in the U.S. Attorney's Office named Tom Larson. And I said, there is some stinky stuff going on in the Missouri State Penitentiary. And he called in an FBI agent named Larry Lean, who spent a full day debriefing me and going through my investigative files. And then that was the last I heard for a while. But then I referred Joe to a local lawyer named Arthur Benson to file a civil lawsuit against the Missouri Department of Corrections for his wrongful conviction. Before they could get the chief investigator of the Missouri State Prison served, the U.S. Marshals were walking up his front walk with a subpoena, or with a summons rather. He got indicted. And it turned out that Joe's case was actually a sex ring within the prison. And the chief investigator falsified all this evidence against Joe because he was getting bribed by the ringleader of the sex ring in the Missouri State Prison. And so as they're walking up the front walk, this is life imitating art. He stuck his service revolver in his mouth and pulled the trigger. It ruined Joe's civil lawsuit, so he didn't get a dime for that. But here he is with his sister the day he got out of prison in 2003. These are my favorite. Ted White Jr. is a Jackson County case. Dale Helmig. Each of these cases has a really powerful story. This is Rodney Lincoln with the brother of the woman he was sentenced to life without parole for murdering, who always thought that Rodney was innocent, but the prosecutor wouldn't let him say anything because he didn't want it to ruin his conviction. Right? This is kind of what we're doing. Ricky Kidd, you may know Ricky Kidd. He's a local case. It's my favorite picture of Ricky. He was on Omna Navas on PBS. We went to Washington D.C. for that, and he's a motivational speaker now. He's doing really well. If you saw the stories about Quentin Lucas complaining about legal settlements by the Kansas City Police Department, running up the tab for that we have no control over our police department, this was the verdict, that he got $14 million for that. That's rare that somebody gets a recovery like that. And my latest was Sandra Hemme, who was released last year. She was convicted and sentenced to life without parole for the murder of a woman in St. Joe, Missouri. Her conviction was based on a false confession. She was a psychiatric patient in St. Joe State Hospital. And again, this was a case where we had to we called in police officers who were experts on questioning suspects. We also called in a psychiatrist who could talk about the medication that she was on. She's over-medicated. She had 6 times the normal dose of Depakote when she was being questioned. She was interrogated 12 times before she finally gave a confession that made any sense at all. And she was convicted on that confession. Her lawyer did, very few things. This is Sandra just a few days before she's arrested. This is Sandra about 6 months before she got out. And so one of the things we've learned is, questioning suspect, interrogations are not investigation. I don't even think that an interrogation deserves to be called that, at least the way we do it. They do them much differently in European and United Kingdom law enforcement agencies. And this is the training. The main focus is to get an admission. Doesn't have to be a confession if they admit to a fact that implicates them in the crime. So for example, I was never there. Oh, we got your fingerprints, right? If they can get them to say they were never there, then the fingerprint becomes sufficient to support a conviction, right? They use a confirmatory bias. The detectives are trained. Yes?
What you read often in books is that the investigator that doing the interrogation can lie to the suspect.
Yes, that is legal. Maine versus Moulton, a U.S. Supreme Court case, allows detectives to lie to suspects. And I've been involved in more than one case where that happened. One of the things they love to do is a prisoner's dilemma, where they have 2 suspects and they're questioning each of them, and they say, this guy's over here confessing and saying you did it. You better get ahead of it. Wow. And so they get this person to make up a story that implicates the other, and between the 2 of them, they get and they try them together. Then it's a cakewalk for the prosecutor. And so these are all methods that they use. This is a wonderful book if you're interested in this phenomenon by Saul Kassan, who is one of the leading experts in America in false confessions. And each of these is a person tried and convicted and sentenced on a false confession. You may remember the third from the left in the top row. That's Amanda Knox. The Italian police used the same thing. One of the things they did to Amanda, this is awful. I've met Amanda. She's a really sweet young lady. She's a journalist. She's a good writer. They told her that she tested positive for HIV, and they needed her to name her sex partners so they could warn them that they needed to be tested. Of course, it was a total lie. But then they used the names to make her out to be a slut when they prosecuted her, right? It was a slut-shaming prosecution. It was horrible. And so it is the method that police are using to take confessions. So we learned to develop some red flags on confession cases. Initially, the suspect will deny it, and there may be multiple sessions before there's finally a, quote, confession. There's persistent leading and suggestive questions to overcome resistance. We know you did this. You were angry because, you know, you were robbing this place, and that's why you had to kill her. And they would go very assertively. The suspect usually is vulnerable. In Sandy's case, she was only 20 years old, but she was also very psychiatrically impaired and heavily medicated for it. When we get the confession, there are discrepancy with physical evidence. One of the really notable, well, there are lots of discrepancies with Sandy. She claimed that she was with a guy who she was hitchhiking, and the victim picked her up. She was with another man she couldn't have been with because he was at work. They went to a pharmacy because she'd read in the newspaper the victim had been seen at a pharmacy over her lunch hour, but Sandy was still in the state hospital over lunch hour. She didn't walk away until 2 o'clock, right? But she put that in her statement, right? Wrong facts in the statement that the police knew, but when she gave, they didn't realize they couldn't be true facts, but they put them in the statement anyway. The other interesting thing were things that were not in her statement that should have been there. So the victim of this homicide was she's a devout Catholic. She didn't show up for religious classes on a Wednesday night. Her mother found the body the next morning. But she was working in the St. Joe Public Library and raising tropical plants to supplement her income. And so if you were to walk in her apartment, you'd see green everywhere. Every horizontal surface was covered with plants. I mean, and if you had been there, you would mention that, right? She never mentioned that. When they asked her to describe the place, she got things wrong. She described a television in a mahogany cabinet. No such television. Didn't even have a television, right? So all of those things. And then Sandy recanted almost right away after she signed her confession. Here's Sandy. Just a couple weeks ago, she sent me this. Dog sitting, her sister's dog. When she was released from prison on July the 19th, she was the longest serving exonerated woman in American history. 43 years, 7 months, 21 days.
Oh.
Yeah. So this is a list of I prepared this slide for the Clay County Bar Association, who wanted to hear a little bit about wrongful convictions. And I wanted to make a point. You see they're highlighted in different colors. These are all of the 54 prisoners. Actually, did I put Sandy on there? Oh, I'm missing one, and it's Patty Pruitt. Should go on there. That's a more recent one that we did. But the color coding are based on whether or not they were exonerated by DNA. CIU is a conviction integrity unit. These are prosecutors' offices reopening possible wrongful convictions. So that's 4. These are innocence organizations. Miracle of Innocence is an exoneree organization. The Innocence Project, they have 2. And Centurion Ministries has 6. The rest of the exonerations were pro bono private practitioners or law school clinics. That's kind of the pattern that you see. These exonerations are the ones that depend on the charity of lawyers. The rest of them are prosecutors' offices and nonprofit organizations. So that's kind of just an overview of the work we do and how clinical students are involved. I've got clinical students getting ready after finals. I thought I had some students who were coming, but they're taking my final even as we speak. I should have made it a shorter test. Yeah. But this summer, we'll be working on a Roger Golubski case in Wyandotte County. And if you haven't heard of Roger Golubski, Google him and you'll find out more than you want to know, I promise. And so we have a hearing in September on that case. So I mentioned that I'm retiring in August, but I'm retiring from the university. I have incorporated a nonprofit so that we're going to continue doing this work. And I'll be doing it with law students and other students. We haven't worked out the details with the dean yet, but plenty of students want to do this work. And so that's going to be, you know, my future for the next few years until I can turn it over. Another interesting thing about being in an academic setting is that it makes it possible for me to do this because thanks to the university, the same amount of money drops in my checking account every month. That's a good thing. You know, and my wife and I live very modestly, you know, in a blue collar neighborhood so that we can afford to pay these expenses out of pocket. And so it's been really a blessing to be able to do this. And then students learn and they move on and they do this. So just last week, one of my former students, Lindsay Reynolds, exonerated Celester McKinney in Wyandotte County, another Roger Golubski case. I was having lunch with a friend of mine who teaches at Yale, and he does death penalty and wrongful convictions work. His name is Steve Bright, really fabulous attorney. And I was talking to him about how great it was. And just as we're sitting down to lunch at Bryant's, we did the Negro Leagues Museum and then we went to Bryant's. I get a text from Jennifer Merrigan, a former student. And she says, I got Anthony Williams out of prison today. I said, yay, that's great. You know, and Steve and I were talking, isn't it great when a former student gets continues the work? And he said, oh yeah, absolutely it is. And then I get a call from my co-counsel on Sandy Hemmy's case to let us know that we won habeas corpus relief. And I normally don't take calls when I'm at lunch with somebody, but I looked to see, it shows up on my watch, I look to see who it is. And it's Jane Pucher, so I pulled out my phone and I showed it to Steve. Oh, this is my co-counsel calling on Sandy's case, I better take it. And he looks at it and he says, oh Jane, she's a former student of mine. So I take it and she's called in to let me know. So 2 law professors sitting having a good time at lunch, and the same day, 2 of our students get somebody out of prison, one in Philadelphia, one in here in Missouri. So it's a great thing. Yeah.
It sounds so naive, but I do not understand why the interrogators, they're police, right?
Mm-hmm.
Why they are allowed to lie.
You'd have to take that up with the US Supreme Court. You know, they put constitutional constraints in a very narrow box. You can do something unless the Constitution says you can't. It's what strict constructionists say. And if you know lawyers who practice in front of the US Supreme Court, you know that there are, you know, the school of thought that the Supreme Court is a living document, that we should interpret it based on the times. Then there are others who say that, well, no, we need to read the text and be limited by the text so that we can apply the values of the slave-holding white men who wrote it, you know. So that is the dominant philosophy. So if you read the Herrera versus Collins decision that I mentioned briefly, Leo Herrera was the guy alleging innocence. Justice Scalia exemplifies that strict construction theory that we look at the text. He's called a textualist. And it doesn't say anywhere in the Constitution we can't kill you if you're innocent. And so, therefore, there's no right. So it doesn't say anywhere explicitly in the Constitution we can't lie to you if you're a suspect, right? And so there is no constitutional right not to be lied to. The difference between the U.S. and other countries, Western countries, is the degree to which our notion of human rights are tied into this document, right? I like to think that liberty is the inherent human condition, and that the Constitution is a limitation on government power. Other countries like the UK, England does not have a constitution. They rely on case law and acts of parliament, but the Privy Council of the House of Lords has the ability to also set policy. But they don't, they view rights as human rights rather than civil rights granted by the Constitution, right? So is the Constitution the light, or is the light coming from somewhere else? And that's the argument. But our current Supreme Court is dominated by people who want to find it in a written text that explicitly says, no, you can't do that. And they haven't found it. That doesn't mean that we can't convince legislators to change the law. I mentioned the Atkins versus Virginia case that prohibits the execution of intellectually disabled people. That was in 2002. 13 years before that, the Supreme Court said there was no prohibition against the execution of intellectually disabled people. And so a lot of people in the death penalty defense community, including me, I wrote the statute in Missouri that abolished the execution of intellectually disabled people. We did that state after state after state until there was this overwhelming, more than a trend, it was a juggernaut of states abolishing the execution of intellectually disabled. And that convinced the court that the tide had shifted on that. I don't know we'd have that same result today, because at that time, the strict constructionists were not in total control of constitutional doctrine like they are today. That's the problem. Yes, sir?
Do you truly think that today capital sentence is still necessary in this country?
No. I think the death penalty is, it's an anachronism, right? We are the only industrial democracy in the world that executes people. Yep. Our only close ally that still executes people is Japan. In 2014, I did a training program for defense lawyers in Osaka and Tokyo. They invited me over to train their lawyers how to defend death penalty cases. And they blame the American occupation for the continued use of the death penalty in Japan. That if not for the American influence, and then of course America executed several Japanese, like General Yamashita and others, as war criminals. And so it sort of has solidified the death penalty. So Japan executes at about the same rate that we do per capita. But I could go on all day about why it's a bad policy, not the least of which is that if we didn't have the death penalty, we wouldn't have a risk of executing innocent people. It is inhumane. You cannot tell me after sitting with Lloyd Schloop in the death watch cell and talking to Joe Amrine through that ordeal that I described to you, you will never convince me that the death penalty is not torture. Under international law, torture is a violation of human rights. And so none of our allies will extradite a wanted suspect, fugitive, to the United States to face trial on a death penalty charge, not because the international community forbids capital punishment. They unanimously forbid torture. And the way we do capital punishment is torture. It's kind of like the Merchant of Venice, right? If you can extract your pound of flesh without drawing one drop of blood, right? Then go ahead, but you cannot extract the death penalty without torture. So many other reasons. People talk about the cost. Why should I pay somebody? It costs 7 times as much to execute somebody as it does to try, convict them, and sentence them and house them for life without parole. There's a lot of reasons for that. One of the big expenses is the expense of a capital trial. A non-capital trial typically is a week or two. They rarely go a month. But a death penalty trial has special requirements about jury selection. Prosecutors get to question jurors in detail about their views on the death penalty, and if they're squeamish about killing the defendant, they get to kick them off the jury. That takes a month just to select the jury. And then you have 5 or 10 expert witnesses on each side. You have the guilt or innocence trial, and then if the defendant's convicted, then you have a penalty trial that can go for another month or two. The last death penalty trial I did, it was 103 degrees outside in the summer when we selected the jury, and when the verdict came in November, there was snow on the ground. And so all of that time, when you think of the court personnel, the expenses of litigation, Kansas did a cost study on the death penalty, and they found that a plea of guilty in a death penalty case cost more than a non-death penalty trial. So it seems like we're just setting money on fire. You know, it's not doing us any good. The time span between the verdict and the execution now is averaging more than 20 years. You know, at that point, I mean, why are we doing this? You know? So yeah, I mean, I think that just from a cost-benefit standpoint, the death penalty should be abolished, let alone all these other arguments about morality and human rights. And the other thing I've noticed is that when you put people on the state payroll, and it's their responsibility to litigate a case to the point where they get to tie somebody down and kill them, I don't like those people. You know, they're not forward-thinking, empathetic human beings if they can do that. And yet here we are, still gearing up. The Trump administration is really ramping up on the federal level. So it's going to get a little worse, and then it's going to start getting better. Yes?
How many law schools have a similar program as we have at UMKC?
There are at least 17 that I know of. The KU has the Paul E. Wilson Project for Innocence. MU has had an innocence clinic off and on. Washington University does not. St. Louis University, I used to teach theirs back before I started teaching here, and I had to quit over there. So they haven't started a new one yet. But they exist in a lot of the different schools around the country. It's kind of, you know, hit and miss though.
Do you find a lot of applicants to our law school or want to come here because of the program we have?
Yes. Yeah, I'm on the admissions committee, so I get those people get steered. We interview everybody who gets admitted, and a lot of those get steered to me. Yes, sir.
One of the things, one of the techniques for interrogation was like just keep it going.
Yeah.
And you see mostly on television, you know, Dateline and that kind of stuff, where they'll interrogate a suspect for like 10 hours, all night, you know, until the wee hours of the morning. And finally they'll say something, you know, when they're starving and half asleep. Is there any kind of judicial standard or that weighs the effect or the result of that kind of, you know, hours and hours and hours of sitting in the room and having the, you know, good cop, bad cop they played against them? Is there any kind of judicial standard about the weight given to something that's achieved after 12 straight hours of?
The answer to that question is yes and no. There is a standard, but it's weak. I recommend a really good book called Devil in the Grove. about Justice Thurgood Marshall's experience as death penalty defense lawyer in the Deep South. And it was really interesting because he started into it right after the Powell v. Alabama, Scottsboro cases that made it to the U.S. Supreme Court, created a right to counsel for people facing the death penalty. And he started taking cases of people in the South who were facing the death penalty for rape charges. And the NAACP did not want the adverse publicity from those cases. And so they asked Thurgood if he would only take cases where he was convinced that the client was innocent. And he said, yeah, I'll do that. That's what he told the hierarchy in the NAACP. And his colleague asked him, how are you going to do that? If you don't know anything about the case. He says, it's easy. I'm just going to ask if he confessed. And if the answer is yes, he's probably innocent. Right? So Thurgood Marshall did the U.S. Supreme Court's early cases on excessive interrogation methods. The first was Brown v. Mississippi in 1933, where the Mississippi sheriff actually came to court and testified at a pretrial hearing to exclude the statement that, yes, I did beat him, but I didn't beat him too hard for a Negro. That was his testimony. Yeah, shocking, shocking. And so that goes up to the U.S. Supreme Court, and the U.S. Supreme Court says no physical violence in interrogation. So that's one bright line. They cannot beat the client to get him to confess, right? That seems like a simple line, but then you could see the collective law enforcement community going, oh shoot, now what are we gonna do? So the next case to go up was Watts versus Tennessee. And they kept him in a dark cell around the clock. They mixed up his nights and days, kind of like what they were doing with the Guantanamo interrogations. And they would, wake him up at, 1 in the morning, and they would interrogate him until, 8 o'clock the next night. And then detectives would come in and do it in shifts. And it took a week to get him to confess. The U.S. Supreme Court said no. They held this guy until he broke. That's unconstitutional. At this point, they're using the 14th Amendment due process clause as a measure. So it violates due process to extract a confession by the use of force or the threat of force or prolonged intensive interrogation. So the next case that comes along is Ashcraft versus Tennessee, where they realized, well, we can't do it for weeks. What they did with Ashcraft is they just kept him awake for 72 hours, continuously interrogating him until he confessed. They had to call in a doctor to make sure that, this is a question of medical ethics, I think. Can you green light interrogation of somebody who's that exhausted and say it's okay? But the U.S. Supreme Court said this continuous interrogation is unconstitutional. Then there was another case that went up to the U.S. Supreme Court later in the 1950s, just before Miranda. I'm having a senior moment now. I'll think of the case in a minute. Pardon me?
Escobedo.
No, Escobedo was one of the early Fifth Amendment cases. But this was a 14th Amendment case where they're asking the court to draw a bright line. And for federal courts, they drew a line that says if the interrogation continues beyond the point that the police can hold him without a warrant. So you've probably heard of the 24-hour rule. Yep. Or in the federal courts, it was the 72-hour rule. But they say once you go beyond that time, any statement you get is presumptively involuntary and inadmissible. But short of that, they look at all of the factors. They'll look at the education, the pressures, the techniques that are used, and law enforcement officers now know better than to say that they deprived somebody of food and water and sleep They'll say, oh yeah, we sought all of his comforts and we continued to interrogate. We gave him reasonable breaks. He got to use the bathroom. We brought him sandwiches. We gave him a Coke. We let him smoke a cigarette, you know, and lo and behold, you know, 23 hours later, he confessed. You know? So it's a loose standard. But yeah, McNabb versus United States and Mallory versus United States is the case that says, that creates that bright line. If it's less than, the presumption works in favor of the government. If it's less than the legal detention. If it's over the legal detention, it gets kicked out. If it's a federal defendant, they haven't applied that to state courts yet. Yeah.
I'm going to draw this to an end.